Chapter 5, Brokerage Procedures. In Chapter 5, you will be presented an explanation on daily operations of a real estate brokerage office, requirements of a principal and branch office, rules governing signs, advertising, record keeping, and conduct. You will also learn the broker's role as an expert in handling escrow funds, rental information lists for compensation, the various forms of business entities, and which may be permitted to engage in the real estate activities. In the end, you'll be able to identify the broker's office requirements, list the requirements for the brokerage sign, list requirements for brokerage advertising, explain timely deposits of earnest money, describe how to determine the recipient of good faith doubt and/or conflicting demands, explain the rules for advertising of rental property and information or list, describe the obligations of licensees for changing employer, address, and moving out of state. You'll be able to describe the various types of business organizations. Vocabulary for Chapter 5. Brokerage offices. Active brokers must have an office. It must be at least an enclosed room of stationary construction. It must have privacy to conduct negotiations. Brokers must keep records in the office, things such as books, real estate transaction files, and the such. If zoning allows, the office may be in the broker's residence. They may even have offices in another state. However, sales associates may not open and register an office of their own. Branch offices. Broker must register each branch office. Branch office registrations are not transferable. A temporary shelter in a subdivision being sold by a broker is not a branch office, unless the sales associates are permanently assigned or sales transactions are closed at that location. Office signs. Trade name if used, broker's name, and the words licensed real estate broker, or it can be abbreviated as such, must appear on the sign. Now, if the brokerage entity is a partnership, corporation, limited liability partnership, the sign must contain the name of the firm or corporation, name of at least one active broker, and again the words licensed real estate broker. Names of sales associates and broker associates are optional, but if they're included, the associates' names must be below the broker's name and must include the license type next to each name, such as sales associate. A line or a space must separate the sales associates' names from the broker's names. Advertising must inform people that they're dealing with a licensee or a brokerage firm. The broker is responsible for all advertising. Advertising must include the name of the brokerage firm. If it doesn't, it's considered blind advertising. Blind advertising fails to disclose the name of the brokerage firm and maybe only includes a P.O. box, telephone number, or street address. Blind advertising is illegal. False, deceptive, or misleading information in advertisements for real estate is illegal. It is a second-degree misdemeanor for false advertising. Team advertising. Team concept allows brokers associates and sales associates to join forces to serve a wider group of customers more efficiently. Teams must advertise in the name of the brokerage firm. Names of licensees in advertising. Licensees may include personal names in ads. They must use last name as registered with the commission when including a personal name in an ad. Yard signs and classified ads must include the registered name of the brokerage firm. Promotional materials must include the name of the brokerage firm, and sales associates' names may also appear. Membership and organizations. Licensees cannot use the term realtor unless they're a member of the National Association of Realtors. Licensees who use the name or designation of an association to lead people to believe a licensee is a member of the association may be found guilty of false advertising. Internet advertising. Point of contact information is the means to contact the brokerage firm or licensee, including mailing address, street address, email address, or telephone or fax number. The brokerage name must appear adjacent to or immediately above or below the point of contact information. For sale by owners, licensees may sell their own property by owner. They can advertise the property and include personal contact information. However, they should disclose that the seller is licensed before beginning negotiations and then again in the contract. Telephone solicitation and the regulation. There's a Florida law and a federal law. The Florida law has a no solicitation list and the federal law has a national do not call registry. The Florida law is maintained by the Department of Agricultural and Consumer Services, and there's a $10,000 fine. For sale by owners exception for Florida, so the Florida law says that we do not have to check the do not call registry before calling a for sale by owner because they have advertised their telephone number. However, the federal law says we have to, and federal law supersedes state law, so therefore we have to. Now, again, the federal law has a do not call registry. Their fine is $16,000. They do not have an exception for the for sale by owners. And just so you know, the Florida list is added to the National Registry, so you really only need to check the Florida law. Exceptions to the National Do Not Call list. When representing potential buyers, you can call a for sale by owner provided the buyer is interested in the property. You can also contact individuals with whom you've had an established business relationship with for up to 18 months. That means you closed a transaction. Otherwise, you can contact customers for 3 months after a business inquiry. Maybe they ask you to send them a list of houses or something like that. Email advertising, the CAN-SPAM Act. You need to include a valid physical postal address and provide a way to opt out of email and honor the request within 10 business days. You need to clearly indicate the person or business sending the message, including the domain name and email address. Let me say a little bit more about this. There is regular emailing a customer back and forth. When you're doing that and you're having a conversation, this doesn't apply. What this applies to is, let's say you went out and got a listing and you want to send your database of 300 people just listed card. That's when this comes into play. When it's an advertising type of email. It's not a personal email back and forth or a business email. Fax solicitations. Yeah, I know most people don't fax anymore, but you still need to know this. Okay, the Junk Fax Prevention Act. The requirements to send fax advertisements. Has to have the date and the time the fax is sent, registered name of the company sending the fax, the company phone number that sent the fax, clearly state opt-out procedures, and include an opt-out notice. Escrows and deposits. Escrow, which is also known as trust accounts. That is an account for the deposit of money that the broker holds in trust for others. Deposit is the money delivered to a licensee in connection with the real estate transaction. Earnest money deposit can be cash or anything that can be converted into money. Immediately defined. Sales associates must deliver to the broker no later than the end of the next business day. Now, weekends and federal holidays do not count. Brokers must deposit the escrow into their account no later than the end of the 3rd business day. If the escrow check is made payable to the sales associate, you need to have the buyer write a new check payable to the broker's escrow account or the title company, wherever the escrow is supposed to be deposited. If that's not practical, you need to endorse the check and write for deposit only to the name of wherever it's going, and make sure you turn it over to your broker. Under no circumstances do you deposit that check in your checking account and get a cashier's check for the buyer. Post-dated checks and insufficient funds. Before accepting a post-dated check, you need to obtain the seller's approval. The broker must secure the check until payable and then immediately deposit in his escrow account. Checks returned for insufficient funds. The broker won't be responsible if the broker made a timely deposit. However, if he did not, he could be disciplined and be responsible for the money that did not clear. The acceptable depositories for broker-held escrow accounts. It can be a Florida commercial bank, Florida credit union, Florida savings and loan. A Florida-based title company or Florida attorney is acceptable if the broker chooses not to have an escrow account. If the broker does choose to have an escrow account, these are some of the rules. The broker must be a signer on the escrow account. Now, the broker can have additional people such as bookkeepers, secretaries, accountants, whatever, but the broker must be a signer on the account. The accounts must be reconciled each month. Now, not necessarily by the broker themselves, but the broker is going to have to review, sign, and date the monthly reconciliation. Title companies and attorney escrow accounts. So if the broker doesn't want to have their own escrow account, this is the alternative. Title companies or attorneys. If that's the case, you're going to need to indicate the title company or attorney name, address, and telephone number on the purchase and sales contract. And within 10 business days after the deposit is due, the buyer's broker must make written request to the title company or attorney for verification of receipt of deposit. Within 10 business days after the broker made written request, they must provide the seller's broker with a copy of the written verification. Interest-bearing accounts, escrow accounts. With written permission from all parties, the broker can have an interest-bearing escrow account. The written authorization has to state who's entitled to the interest, and the broker, if authorized, may receive the interest earned. Now, there's money allowed in the escrow account other than the escrow money to maintain it. Brokers may place $1,000 of personal or brokerage funds in a sales escrow account. Think of it as buffer funds for the monthly bank charges. Maybe you need to order a copy of a check or something. You cannot use the escrow money to pay those because that's called conversion and that's illegal. So brokers are allowed in the sales escrow account to keep $1,000 of buffer funds, and in property management accounts, $5,000. Now, the escrow accounts do not have to be separate if they have both sales and property management. They can have one escrow account. It's preferred that they have two because it's easier to maintain that way. But if they choose to have one, the maximum amount in the one account is $5,000, not $6,000. Brokers must keep business records, books, and accounts in compliance and available for DBPR audit. Brokers must preserve records for 5 years and 2 years beyond any court proceeding. Trust funds must be kept in a separate account. That's our escrow account, trust account, whatever you choose to call it. Commingling is the illegal practice of mixing another funds with broker's money. Conversion is the unauthorized control or use of another person's property. Like, for example, paying your bank service charges out of the escrow account. You can't do that. That's why they allow the buffer funds. Now, notice and settlement procedures. Brokers must not disperse escrow funds until the transaction closes or with the agreement of the parties. They have to be identical agreements, identical instructions. A broker has conflicting demands when a buyer and seller make demands regarding dispersing of escrow funds that are inconsistent with each other and cannot be resolved. When you have conflicting demands, and this also goes for good faith doubt, which we'll talk about in a minute, the 15-30 10-day rule applies. Now, this is only if the broker is holding the escrow money in their own broker escrow account. If a title company or attorney is holding the money, this does not apply. So, the broker must notify the commission within 15 business days of receiving conflicting demands. Now, within 30 days of receiving the conflicting demands, the broker will need to begin a settlement procedure. If the dispute is settled or it goes to court, the broker then has 10 days to notify FREC that it indeed is either settled or it's going to court. Settlement procedures. Mediation, arbitration, litigation. It's remembered by the acronym MAIL. Mediation is an informal, negotiated settlement that is non-binding. Arbitration, with prior consent of all the parties, a binding judgment is issued by a third party, an administrative law judge. Then there's litigation. That's going to court. If the broker has no financial claim, he will file an interpleader, deposit the funds with the court, and the court will determine who should get the escrow money. A declaratory judgment is filed when the broker believes they're entitled to a portion of the escrow funds, and the judge declares each party's rights to the funds. And then there's the escrow disbursement order, known as an EDO. That's when the broker asks FREC to make the decision as to who should get the escrow funds. The commission issues a determination of who's entitled to the disputed funds when the broker requests an escrow disbursement order. The funds must be held in a brokerage escrow account, and the broker must inform FREC within 10 days if the dispute is settled or it goes to court. Exceptions to the notice and settlement procedures. Brokers are not required to notify the commission or start a settlement procedure in these situations. When it's the sale of a HUD-owned property, a timely notice to cancel a residential condominium contract, or failure to satisfy the financing clause in a contract. Good faith doubt. Remember I told you about good faith doubt. Rules are the same. It's the 15-30 10-day rules. That's when a broker doubts either party's intention to act in good faith according to the contract. Broker must notify the commission in writing within 15 days of having the doubt. Begin a settlement procedure within 30 days of having the doubt. And the broker has 10 days to notify the commission if the dispute is settled or it goes to court. Rental information. Advertising rental information or lists that are not current or are materially inaccurate are illegal. Any person who violates the requirements is guilty of a misdemeanor of the first degree and is subject to a fine of up to $1,000 or imprisonment of up to 1 year in jail and subject to license suspension or revocation. Brokers who provide rental lists for a fee must provide customers with a receipt that contains a provision which states the customer may request within 30 days a return of 100% of the fee if the information is inaccurate and 75% if the customer did not secure a rental from the list. Sales associate's commission must be paid by the associate's employer and not directly by the buyer or the seller. Associate split is determined by agreement with the employer. Associates may not operate independently. The broker's commission is established by agreement between the broker and the party who agrees to pay it, and it is negotiable. Antitrust laws protect competition and ensure against the restraint of trade. Sherman and Clayton Antitrust Acts and the Federal Trade Commission Act is what oversees this. It is illegal to fix commission or fees for services. That's price fixing. It's also illegal to conspire to split up market areas to avoid competition. That's called market allocation. Liens on residential property for non-payment of commission are allowed only if the broker is given that authority in a contract. Otherwise, the broker would have to seek civil judgment. And just an FYI, sales agents cannot sue the seller for unpaid commission. Your contract is not with the seller. Your contract is with the broker. The broker can sue the seller. You have to sue the broker. Kickbacks. Nasty word. Referral fees for non-real estate services are allowed if the buyer and the seller are fully informed. It must not violate RESPA. It's illegal for closing services, title searches, appraisals, etc. Now, a person receiving the kickback must be properly licensed if applicable. So, for example, referral of a loan or referral of mortgage company. If the licensee has a mortgage loan originator license, they can receive a referral fee. If not, they are not allowed to receive the referral fee. Referral fee for real estate services. Licensees may share their commission with the buyer or seller in a transaction with full disclosure. They may not share their commission with any other unlicensed person. They may not pay an unlicensed person for a referral of real estate business. Remember, the only one is a tenant referral fee of $50 that we discussed earlier. Change of employer. Sales associate license ceases to be enforced when an associate changes employer. The DBPR must be notified within 10 days after the change to the new employer. Associate may not conduct real estate services until registered under the new employer. And remember, there is a fiduciary relationship between the associate and the broker. And what that means is when you're leaving XYZ to go to ABC, you're not going to try to take all the agents with you and the trade secrets and divulge them to your new employer. Brokerage business entities. Chapter 475 defines a broker to include anyone who is a general partner, officer, director of a brokerage partnership or corporation. Chapter 475 prohibits a person licensed as a sales associate or broker associate from registering as a general partner, officer, director of a brokerage entity. Types of businesses that may register as a brokerage entity. Sole proprietorship, general partnership, limited partnership, limited liability partnership, corporation, and limited liability company. A sole proprietorship is owned by one person. The owner has all the liability and must hold an active broker's license. And it can be registered under the broker's own name, the owner, or a trade name. Brokerage, general partnership in real estate. They must register the partnership with DBPR. At least one partner must be an active broker. Partners who deal with the public and perform real estate services must be active brokers. Sales associates may not be general partners. Ostensible partnership, also known as quasi-partnership, is when the actions of two or more persons create the appearance that a partnership exists. Each may be liable for the other person's debts and torts. Torts are the misdeeds, and their license may be subject to suspension. A real estate brokerage limited partnership, again, must register the limited partnership with DBPR. Also, the general partners who perform real estate services must be active brokers. At least one general partner must be an active broker. All other general partners must register with DBPR. Sales associates may not be general partners, and limited partners do not register with the DBPR. Real Estate Brokerage Corporation. They register the corporation with DBPR. At least one officer or director must be an active broker. Active and inactive brokers and unlicensed people may serve as officers and directors. Must be active brokers, though, to perform real estate services. Remember that anybody that's going to be what I call a grand poobah in any of these business entities, if they're going to practice real estate, they have to have an active broker's license. Unlicensed officers and directors register with the DBPR. Again, sales associates may not be an officer or director, but they can be a shareholder. Limited liability company. That has the best features of a corporation and a partnership. There's protection from personal liability, and IRS treats LLCs as a partnership for tax purposes. Income is taxed only once, as in a partnership. Death of the only active broker. If the only active broker of a broker partnership or corporation dies, resigns, or is removed from office, the vacancy must be filled within 14 calendar days. No new brokerage business may be conducted until a new active broker is registered with DBPR. Failure to timely replace the broker results in cancellation of the registration, and the licensees become involuntary inactive. Temporary brokers. Vacancy of an office may be filled with a temporary broker. They must be registered with the DBPR. A temporary broker can be utilized up to 60 days without need to comply with the Secretary of State registration requirements. Failure to appoint an active or temporary broker within the 14-day deadline results in automatic cancellation of the brokerage's DBPR registration. Business entities that may not register as a brokerage. Corporation sole, that's a church organization. Joint venture, which is temporary business arrangement. Business trust involves the entity's own property. Cooperative association, again, involves own property. And an unincorporated association is an example of property owners in a subdivision. Now, just so you know, a real estate brokerage can be a nonprofit organization. They can be a nonprofit organization. Business names other than the legal name of the person doing business is known as either TA or DBA. TA is for trading as. DBA is for doing business as. Fictitious name refers to the name registered with the Department of State. Brokers who operate under trade names must also register the trade name with DBPR. Associates must have their licenses issued in their legal names, not under a trade name. Forming a professional association in an associate's legal name. Sales associates and broker associates may organize themselves in a type of professional association in their legal name. Some examples would be Sally Smith, PA, or Bob Brown, LLC. DBPR license must be issued in the licensee's legal name, including the professional designation. Personal assistants. There's licensed and unlicensed. Unlicensed personal assistants, they perform administrative tasks. They're not allowed to perform duties requiring a license. They cannot be paid commission. The licensee who employs the unlicensed assistants has to comply with the state and federal employment laws. Licensed personal assistants can perform services of real estate. They must be registered with the employing broker, and the broker must pay the licensed assistant for brokerage activities.